Good evening and welcome to the April 19th, 2016, 5:30 p.m. Commissioner hearing. Could you please stand and join me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much for joining us tonight. A few housekeeping items before we get started. If you wish to testify tonight, either during our open public forum or for any of our agenda items, I need you to fill out one of these forms. They're right outside the door, and hand it in to our clerk. I do have a pile here already. Also, if you have a cell phone, if you can silence your cell phone, and if you do end up taking a call, if you can stand far enough away from the door when you speak that it doesn't interrupt the hearing, that would be great. So we do start every one of our evening hearings with an open public forum, and this is an opportunity for the public to speak on any item that is not on our agenda tonight. So we're going to go to the first of two open public forums. I have two people that are signed up tonight. Again, these are for any items not on our agenda tonight. So I have Dan Miller. Yep, you have 3 minutes, please, and thank you. And if you'll state your name and address for the record.
My name is Dan Miller. I live at 6104 West Dental Road, Spokane, Washington, 99224. My comments regard a parcel of land which is at the corner of Grove Road and Greenwood Road, which is in District Number 3. What has happened is in late 2013, people established residency by moving in a travel trailer there, which had no water, no sewer system to it. In the preceding months, they started bringing in commercial trucks dumping yard waste, other types of garbage and refuse on the property. In my checking out, this company has no business license with either the state or the city. And they are currently in business. I called their number again today. I have gone through numerous agencies, including filing a complaint with code enforcement over a year ago. The building department, on the second page here, is a list of all the agencies that I've contacted regarding this problem. I'm speaking for our neighbors also that have contacted these agencies. And just nothing seems to be getting done with the problem. It is getting worse. They are in there continuously. Like I said, they live there off and on. There's other problems that we have noticed, some that could be criminal, but nobody has listened to us. We are trying to get somebody to take action against this and get some type of response from this problem.
Great, thank you for taking the time to share. Commissioner French.
I am familiar with this. I know that you've contacted Karen Corkins, my executive, and she's been working on trying to get a response as well in terms of some activity on your complaint and stuff. So thank you for being here. Thank you for the photographs. It is on our radar in terms of trying to join you in getting some action on this.
Okay, if you need additional photographs, I have many of them, and I've worked with Terry Otteson also on this problem. Okay.
Great, thank you.
All right, thank you.
Our second person tonight for open public forum is Tim Williams, Community Frameworks. Tim, welcome. If you'll state your name and address for the record, please.
Hi, my name is Tim Williams. I work with Community Frameworks. I live at 210 West 36th. Tonight, I just want to give a short 2-minute thank you to the commissioners for an award that you gave to Community Frameworks last year for affordable housing. We have a project that is under construction at West 315 Mission. It's diagonally across from the big rock at North Central High School, and you might go, what is that project? Well, that's a project that your funding, significant funding that we got last year, helped enable. And that project's going to build 32 low-income affordable housing units, including 7 residents who were formerly homeless, 7 residents who have disabilities, and it's a real contribution to that area. So I just wanted to say thank you for that award. We got a much larger award than usual on that particular project, but that helped make that project possible, and we were then able to go and get low-income housing tax credit funding to complete the funding round for that project, which had multiple sources. So it takes flexibility nowadays to do affordable housing. A lot of times you have to get money from 3 or 4 different places, and you have to have good local partnerships and participation. And while we are happy to build in the county as well as in the city, this particular project happened to work out in the city, but the residents that are going to live there are going to come from all over. So again, just a quick thank you and a notice, so when you see that building and drive by that, to know that you helped make that possible, and thank you very much.
Thank you, Tim, for sharing with us. Appreciate it. All right, those were all the slips I had for open public forum. This is an opportunity for individuals to speak on any item that is not on our agenda tonight. Is there anyone else who wishes to speak in the open public forum? Second call, anyone wishing to speak? Third and final call. Seeing no one moving forward, we're going to go ahead and move on to item number 4 on our agenda tonight, which is the proclamation to proclaim May 1st through 7th, 2016, National Travel and Tourism Week. Commissioner French.
So I'm going to read this into the record as a motion in the matter of proclaiming May 1st through 7th, 2016, National Travel and Tourism Week. Whereas travel has a positive effect on Spokane County, Washington State, and the nation's economic prosperity and image abroad, and also impacts business productivity and individual travelers' well-being. And whereas travel to and within the United States provides significant economic benefits for the nation, generating more than $2.1 trillion in economic output in 2015. And whereas visitors to Spokane County spent $947 million in 2015, contributing $64 million in local and state taxes. And whereas for every $85,960 of visitor spending in 2015 supported the creation of more than 10,000 tourism industry jobs in our community. And whereas the hundreds of thousands of visitors who traveled to Spokane County in 2015 spent time at destination attractions, including golf courses, historic sites, the Spokane County Fair and Expo Center, and more. Now, therefore, the Board of County Commissioners of Spokane County, Washington, hereby proclaim May 1st through the 7th, 2016, as National Travel and Tourism Week in Spokane County, and encourage all officials, employees, schools, and residents to participate in travel and tourism celebration activities to reflect on the enormous impact the industry has on all of our well-being, dated this 19th day of April 2016. And I think we have Ms. Cheryl Cadet in the audience to receive the proclamation.
We have a motion.
Right.
Second your motion?
We have a motion and a second. Any discussion on the motion? Seeing none, all in favor say aye.
Aye.
Passes 3-0. Welcome, Cheryl. Cheryl Kilday is the President and CEO of Visit Spokane. Please.
Thank you so much. No, we really appreciate the support of you as commissioners and of the county, and we have beautiful tourism assets because of the golf courses and the things that you have with the parks and all the things that you do. And as a community, we really appreciate the support as well, because it's not something to take for granted. It was only in 2011 that Washington zeroed out their state tourism office, and that's had a negative impact on us. It makes our job a little bit harder, but we're still seeing success in Spokane, and our community really values the tourism that we get. The jobs that are created, that $85,000 per visitor spending creates one job. It doesn't take that much money when you really think about it. I was at the Hotel Association this afternoon sharing some of the groups that we have coming in the next couple of years and how so quickly that economic impact adds up. This week, we've got the World coming with the figure skating event, and it's a first-time event, and it's a resume builder for the entire community, for the region, because it shows that U.S. figure skating has that confidence in us to be able to pull off a first-time world event, and the world will be watching through the televised event, and the people that will be coming to see it here live. So there's so much within our region that we benefit from, the ability to have those visitors come in and fuel our economy. And I just wanted to share just one last figure. So in the proclamation, it's got the $64 million in local taxes. Of that, 23 million are local, and the 41 are state taxes, but those local taxes are the cash registers that are ringing throughout Spokane County. So thank you very much for this, and we look forward to having a great tourism week.
Great, thank you for joining us, Cheryl. Okay, so item number 5 on our agenda is a hearing item in the matter concerning the proposal to declare certain miscellaneous county personal property surplus and authorize its resale, project number P9773, and we have Terry Roberts with us tonight.
Thank you. You'll note there are a number of items listed. Some of them are going for auction. Some of them we've used every bit of life out of them, and they're going for destruction. There's some items that should not be sold to the public, and those are going for destruction also. And what can be recycled will be recycled. And we have a couple of things set up for that. Outside of that, are there any questions?
Were there any questions for Terry? Okay, this is a public hearing item. If anyone wishes to testify on hearing item number 5 tonight, this is your opportunity to do so. I do not have any slips of paper. Hearing item number 5, anyone wishing to testify? Third and final call for hearing item number 5. Okay, seeing no one coming forward, I will go ahead and close the hearing and look for a motion.
Madam Chair, I would move that we authorize the disposal, or authorize the proposal to dispose of certain miscellaneous personal county property by auction, recycling, or destruction as described in project number P9773.
Second.
I have a motion and a second. Do I have any further discussion on this motion? Seeing none, all in favor say aye.
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 Passes 3-0. Thank you, Terry. Hearing item number 6 on our agenda tonight, in the matter of 2015 Annual Comprehensive Plan Amendment 15-CPA-01 with the concurrent zone reclassification. Mr. Peterson, it's all you.
Thank you, Commissioners. For the record, John Peterson, Planning Director. Mr. Davenport and I are going to share some duties tonight. He'll be giving the bulk of the presentation. I just want to give you a brief overview of tonight's activity. You should have before you, one is the staff report on this item that was presented to the Planning Commission, as well as a complete packet of the information that comprises the record that shows all the matters before the Planning Commission, the comments from the public, as well as agency comments to date on this action. Just a couple items of clarification. This is 15 CPA-01. This is a comprehensive plan amendment only. In this case, it is not a zone reclassification that's concurrent in this matter. It is only a request, again, to change the large tract agricultural designation to the mineral land designation on 78 acres in northwest Spokane County. Property owner's name is Mr. Ron Calhoun. He's represented by Don Howell. Again, this comprehensive plan amendment is a two-step process. First step is before you tonight to consider the recommendation of the Planning Commission, which was a 3-to-1 vote. Because of the makeup of the Planning Commission at that time, it was only a 3-to-1 vote to approve. It did not constitute a quorum of the members, and therefore it essentially is a no recommendation at this time. Mr. Davenport will note that whenever we look at a comprehensive plan amendment request to redesignate mineral lands or any resource lands, there are very specific policies that are applicable. In this case, Steve will outline those as noted in the staff report. Should you in the future choose to approve this comprehensive plan amendment, there will be a second step of the process that would require a public hearing before the county hearing examiner on the zone reclassification of the site. And at that time, the hearing examiner would consider site-specific information with regards to a site plan, amount of materials to be removed from the site, hours of operation, haul road location, buffering, and any other mitigation measures that the hearing examiner would find appropriate based upon the activity and the scope and scale of the use. I would note that this application does have a previous history to it. It was subject to a previous conditional use permit application before the county hearing examiner. The conditional use permit process has separate criteria for mining in the existing large tract agricultural zone. The hearing examiner did make a previous decision on that to deny that application for a conditional use permit for the reasons that the applicant could not meet all the applicable criteria for the conditional use permit. Those same criteria do not apply in a mineral land mining zone designation. So that's why the applicant is here seeking a different path. The CUP is not before you. That's already been decided by the hearing examiner. And this is a different path to redesignate the property to a mineral land designation. And should that be successful, the applicant would have to come back and seek a zone reclassification to demonstrate consistency with the criteria in the zoning code for a zone change. I think that's all I have. Steve has more detail, and we'll run through the staff report and cite the applicable policies in the comprehensive plan. They are very detailed and very specific in this matter. I think you'll see that the record and the staff report will show you how the proposal comports with those policies.
Good evening. I'm Steve Davenport, Senior Planner with Spokane County Department of Building and Planning. And so the request before you, the file number is 15-CPA01. And as John said, it is a comprehensive plan amendment from large tract agriculture to mineral lands on 78 acres. And I have some maps here for the Planning Commission. We did make some larger maps that show the site, and so you can see on this larger map, the site's here, it's 78 acres, and you can see the surrounding property. This is Brooks Road, and actually Brooks Road, as you look at this map, the county right-of-way ends right here, where there's a sharp turn in Brooks Road. And this road going up here is actually an easement. There's also another easement, paper easement, that goes along this property line up into here. The nearest rural arterial is about 3 miles to the south in Cooley Height Road. So on the site, we have an existing single-family residence. It's located about right here. It's kind of hard to see, it's small. And then there are other single-family residents to the south and all along Brooks Road, and then also to the west of the site are some single-family homes. The site is what would be classified as channeled scablands from the Great Flood of many years ago. As you can see on the map, there's wetlands, there's rock outcroppings. It's really kind of rough terrain up there. So as part of this project, let me put this other map up here. I think the bigger maps are probably a little better to see what's going on. On this other map as well is an oblique view from our county pictograph. So you can see the site is up here. There's some wetlands here, wetlands to the east of the property. Mr. Calhoun's home is located right here. The Kopecki's are directly south here. This is Brooks Road easement, Brooks Road, and then there's another easement that goes along here and accesses this southeast corner of the site. So the Department of Building and Planning, we did an environmental review on this request under the State Environmental Policy Act. And through that process, we made a determination of non-significance on October 14th, 2015. So basically that means we made a determination that an environmental impact statement was not necessary for this project. The appeal period for that expired on October 28th, and it was not appealed. The Planning Commission held a hearing on October 19th, 2015, and that hearing, as you'll see in their findings of fact, was consistent with all the requirements for public notice, environmental review, and all of that. So I'll just reference that here. In terms of your public hearing, there was public notice that was in the spokesman review on March 15th, 2016. Additionally, we mailed to all of the property owners in the surrounding area as required within 1,000 feet of the site. And also any parties of record from the Planning Commission's hearing were given notice, as well as circulations to agencies of jurisdiction. So as John mentioned, there was a previous land use action on this by the hearing examiner, and that was file CUW-3-14. That was a conditional use permit. So in the large tract agricultural zone, which this parcel is, rather than doing a mining change, you can apply for a conditional use permit to do mining on a portion of the site. And the applicant did that back in 2014. The hearing examiner denied that based on that the project couldn't meet some of those approval criteria, which were somewhat a little bit different than what's required when you do a full mining reclassification. And he also cited impacts to neighboring properties from the proposed mining use. So the staff report has a fairly detailed analysis, and this project is somewhat complicated in that you're actually doing two things. So the analysis is kind of a two-pronged analysis. First, you have to determine, is this site eligible to be declassified or taken out of the large tract agricultural category, which is a pretty protective category in the GMA. There's a lot of emphasis on retaining agricultural areas and not converting those to other uses. So we do have very specific policy on how to change that designation and criteria that have to be met for that to happen. Then the second part of the analysis is if it's eligible to be reclassified to another zone, then there's additional criteria for classifying a site for mining. So there's a whole list of criteria that have to be met in order for a mining site to be approved. So I'll just take those one at a time. So for the first one, is it appropriate to remove this site from the agricultural designation? And there's the criteria is listed under policy NR 1.1.4, and we've got a lot of people here that want to testify, so I'm not going to go through every single one, but I'll just give a little overview. Basically, that criteria is heavily weighted on what kind of soils are on the site. So if you have prime soils or soils of statewide significance covering the site, it's not likely that you're going to meet the criteria to redesignate that. For this proposal, the applicant went to the Spokane County Conservation District, and they did a study of the soils on the site and looked at those, and it's pretty obvious just looking at the map, those are not very good soils. It's mostly rock outcrops and maybe 1 or 2 inches of dirt out there. So they're really class 6, 7, and 8 soils, generally for agricultural designation, you want class 1 and 2, maybe some 3. So in going through that criteria, yes, it meets that criteria to be reclassified from large tract agricultural to another zone. So making that determination, then the next analysis would be looking at the criteria for designating a parcel as mineral lands. And that's found in our comprehensive plan under policy NR.4.14. And there's quite a list of there, and it's analyzed in the staff report, so you can see all the details of that analysis. But basically, converting to mineral lands, the criteria talk about compatibility with adjacent land uses. There's a minimum site size requirement of 20 acres, which this site would meet. And then the applicant has to show that the size and extent of the resource is adequate to convert it to a mineral land designation. So there's a minimum resource amount that needs to be on the site to get this classification. And then there's also criteria looking at environmental considerations as well as transportation impacts. And so those are all under NR.4.14. And we did an analysis of that in the staff report. Some of these are subjective, that U.S. decision makers will have to weigh impacts versus proposed use, and make those kind of determinations in your decision-making process. So, and as John pointed out earlier, this converting to mineral land in the zoning is a little bit different than all of the other. We change the comp plan, we change the zoning at the same time. Mineral lands is different because of when the new zoning code was written and things were changed over, there was a sense that mining has potentially significant impacts. You can have batch plants where they mix asphalt for roadways, which can have a lot of odors, a lot of noise. There's oftentimes a lot of truck traffic. There can be blasting. So there's a whole array of potentially highly impacting things that can happen on a mining site. So it gets this extra scrutiny. At least that was the design when the comp plan and the code were put together. It gets the extra scrutiny of going through very detailed review with the hearing examiner where he can look at the legal issues, he can look at the impacts, and try to mitigate those as best as he can. So with that, I would just conclude my report, and if you have any questions, I'd be happy to answer those.
Madam Chair, if I might want to add just a couple more remarks. In the staff report, Steve kind of walked you through the procedural process here. Again, it's just 2 steps, and I think that first step that he referenced was, does the site really meet the criteria for designation as long-term or large tract agricultural? And I think you'll see on page 4 of 8 of your staff report, you'll see that notation that Eric Choker from Spokane County Conservation District concluded that the site is not consistent with the criteria of policy NR.1.4 and is eligible for the reclassification. That NR 1.4 really refers to strictly the situation of if you don't have the soil types that really are defined as large tract agricultural, then you should be something else. But when we adopted the zoning code in 2001, there was not a site-specific analysis of every individual property, so it was a very broad brush approach of designating areas large tract agricultural. And so this is the process by which someone can provide documentation to say, you know what, based on this information, the detailed analysis would tell you that the property does not meet that criteria for large tract agricultural designation. And then the next significant citation in the staff report would be on page 5 of 8, and that's policy NR.1.9. And that provides you with a policy guidance from the comprehensive plan that says if you're going to change a resource land designation to something different, It shall only be revised through a comprehensive plan amendment and based upon those criteria, such as an error in designation or new information on the resource land or critical area status. In this case, we make that conclusion that, based upon the information from NRCS, Mr. Choker, that the soil types themselves do not support the designation of a large tract agricultural designation. And then the applicant provides further documentation that there is information regarding the amount of material on the site consistent with policy NR 1.8, which is cited on page 5 of your staff report also, that says if you're going to designate a site appropriately as a mineral land, it has to meet the criteria of policy NR 1.8. And the criteria there are listed A through F. It talks significantly about the mineral land resource designation should be 20 acres or more in size. It has a minimum deposit size of 500,000 cubic yards of material. I think you'll see then that there is a response to each of those criteria in your staff analysis that shows how the applicant has demonstrated consistency with those criteria based upon the record that's before you today. And so I just want to make sure you look at those. Those are really the criteria that kind of leads you in the discussion of consistency with the comprehensive plan as your policy-making document in considering this change. And then later, if in fact you decide to approve that, there's a whole separate process for the zone change criteria, and that's up to the hearing examiner. So I just want to make sure you look at those policies, and those are your guiding documents when you consider changing your resource land, because it doesn't happen very often, and the criteria are very, very specific in the comprehensive plan to do so.
Correct. Do you have any questions for either? Go ahead.
Yeah, I'm trying to get my notes. Okay, so one of the criteria says access shall not be through a residential neighborhood. And so when it's looking at the response for F, that's Brooks Road coming down there. So I just want to make clear that the mining is not expected, the trucks are not planning to come down Brooks Road, or where's Bruce?
That's to be determined. I mean, I think, you look at, the term residential neighborhood is not defined. This is a rural land use designation. These are large lot agricultural parcels, resource land designations. Residential neighborhood to me has a connotation perhaps of something perhaps more dense than parcels on 20 acres or 40 acres or size. That's very subjective.
Right.
At this point in time, I think the hearing examiner concluded that they have legal access to the property, but at the present time, appropriate haul route has not been determined. That would be something that would be for the hearing examiner to say, which means of access to the property would the applicant use to remove materials? And if that's the case, then that ingress, egress is something that the hearing examiner can mitigate by limiting the number of trips, specifying the haul road agreement. That's a situation where the applicant would have to enter into agreement with the county engineers. When you talk about mineral lands, there's a requirement for a haul road agreement that would specify the number of trips, what that route would require, and any level of improvement to the roadways that provide access to the property.
I just want clarification that for their response to here, they didn't mention Brooks Road per se, so I'm wondering, I just was wanting to know where Bruce Road is, and as a rural local
I can answer
access-
that. There was a typographical error. That should be Brooks Road.
That should be Brooks Road, you're saying, instead of Bruce Road?
At the bottom of page 6. Somehow Bruce got in there, but that should be Brooks Road, so.
Oh, so the only access in is through
The
Brooks
the only
Road?
current access to the site is Brooks. That's pretty much the road they're going to have to use,
And there's
unless they
about
build
a-
a completely new road.
And there is
through
about a
other
dozen
property.
homes on that
There's,
road.
there's large lot, rural residential homes on pretty much all of Brooks Road on 10-acre or larger lots.
Okay, so I was just wondering, I was thinking, I didn't see Bruce Road, so thank you for,
no.
so it's Brooks, supposed to say Brooks.
Yeah,
Okay,
Bruce
thanks.
is Brooks. Apologize for that typographical error, but that should be Brooks Road.
Thank you.
Commissioner French.
So going back on page 6 of 8, for the criteria under NR 1.8. Item B talks about mitigation of adverse impacts from mining on adjacent property shall be prime designation criteria. What are the impacts that are being referenced there?
That's to be determined.
Okay.
Because mining, in many circumstances, can consist of a lot of different kinds of activity. Many situations, mining could be sand and gravel removal, it could be cleaning, it could be washing, it could be a batch plant, it could be an asphalt plant, it could be crushing, stockpiling, and those are the kind of impacts that are measured by the hearing examiner when you know the details of the application as far as the site-specific. In this case, from what I know of the record, this would be simply removal of basalt. There would be no batch plant, there'd be no cement manufacturing. It's simply removing the present material that I think, if you look at the photos that are part of the record, I think that Mr. Howell will show you shortly, this is material that is used in landscaping, ballast-type material, very large crushed basalt that can be essentially removed by, a backhoe and tipping and scraping the material. So I think it really depends on the scope and scale of the activity. We know some mining pits are very deep. They remove gravel, they wash it, they process it, they sort it. In this case, I believe the only thing we're talking about is removal of basalt.
Okay.
Well, I think in terms of the impacts, what we heard at the Planning Commission from the community was the concern about the truck travel on Brooks Road and how that would impact their lifestyle and their...
Was there anything entered into the record that talked about the volume of truck traffic that might be present?
I don't recall that being
Okay.
included in the hearing.
I certainly think the applicant could speak to that when they have their chance to speak. And also,
Okay.
as part of the review process at the zone change level, that's also something that can be mitigated by the hearing examiner to limit the number of trips per day and hours of operation, to limit the scope and magnitude of those kind of impacts.
So then, moving down to item E, it talks about designations shall not occur on lands with wetlands. And in the description of the parcel, then Mr. Davenport, there is wetlands present. I mean,
Yeah.
it's more scab
Yes, and
wetland than
there
it
actually was a
is.
wetland study that was done for the conditional use permit, and those have been identified. It would require buffers to those wetlands where their operations could not occur within those buffers, but there are some valuable wetland sites on there and in that area.
Okay.
And as I
And-
recall, Commissioner French, the wetland delineation did show that the buffers that are required under the critical area ordinance would be maintained there'd be no removal or alteration to the wetlands.
Okay.
And if so, even if they were to be disturbed or maintained, they could be mitigated on-site with enhancements within the property.
Then the last item, item F, access shall not be through a residential neighborhood. This isn't technically designated a residential neighborhood, even though that it does have residences present, it's still large tract ag.
Correct, it is a large
on
tract
all of
agricultural
that
designation.
designation there. So when it talks about shall have adequate access for trucks, that's again something that'll be determined as part of the application itself, not necessarily the underlying zoning for the property.
Correct.
Okay. Thank you.
Commissioner McLaughlin.
So I don't know how you mine basalt, but I'm just wondering, is blasting involved in this kind of
It can
operation?
be, and there's a very specific and separate permit process for blasting that works through our office.
I wasn't hearing that very
There is a process by which, if blasting is necessary to occur, that is licensed through our office. So blasting can be part of a mineral lands extraction, but, I don't know to this extent whether that be required on this site or not. If it is, then there's a very specific process they would go through with our office to make sure that it's done consistent with applicable codes and ordinances.
Okay, and my concern, I've heard stories on blasting whenever there's any kind of homes in a nearby area is having to do with wells, people's wells collapse. Is there some sort of ruling or rule around that as far as what if somebody's wells stops functioning, and how do they prove that? Is there some sort of a?
It's really more of a civil issue amongst those individual property owners, because, you know, a lot of things could happen to a well that may impact it. Could be just depending upon the runoff from the year, drought conditions, et cetera. So the requirements for blasting are something that we look at very critically. If they're going to blast, and they have to make sure that they comply with, again, the applicable standards that regulate blasting.
So it's a civil issue, but there's no protection for the homeowners closest around there, like they've never had an issue with a well and the blasting starts, and there's no protections back for them from our.
It would be more of an enforcement issue we'd have to look into at that time. You'd have to demonstrate that there is a relationship to, perhaps from a blasting to an impact upon a well.
I'd be curious to know then on the hearing examiner, so do the homeowners in the area, if this goes forward, can they have some sort of a examination of their well, the condition before things started going, so they'd have a baseline so that they would be protected? Is that?
If they have an existing, registered well, they would have well logs and everything like that would indicate the depth of their well. If it's registered with Department of Health and Regional Health District would know the depth, typical volumes and flows, and if that's impacted, then there would be a resolution.
Okay, thank you.
Other questions for staff? Okay, this is a public hearing item tonight, so we will go ahead and open this up as a public hearing. I have folks who are signed up to speak. If you wish to speak and have not filled out a form, they are outside the door, and you can fill one out and turn it into our clerk. First up tonight, we do have quite a few forms, so if you can limit your comments to 3 minutes out of respect for those who are here tonight. First up, we have Stan Peterson, and if you'll come forward and state your name and address for the record, please.
All right. When I wrote this up, I read it, and it came out exactly 3 minutes. However, I've heard a few things from these fine gentlemen that I would wish I had more time, because I would definitely challenge them.
Can you state your name and address for the record, please?
My name is Stan
Thank
Peterson,
you.
and I live about a mile to the west on Ritchie Road. And first of all, I'm strongly against this proposal. Most of us moved to the country to get away from the noise, the pollutants, and cramped style that you had in the city. And we moved to the country, we moved out there to have our little farm, some forest land or some rock, outcroppings. I might say that some of the things I heard these fellows say, I also have on my land, and I was able to raise 30-some head of cattle. It's not solid rocks, I'll guarantee you, even though I have not been down to their property. And I raised some alfalfa in places, and I know of other neighbors that are doing the same thing. And I'm just telling you that it's probably not all going to be that way. It's a beautiful area, and we want to keep it a beautiful area. The southwest winds bring us dust at times from farms, but it's a different kind of dust. I would want to have that rock analyzed and see if there's crystalline silicates in it, because if there are, that is a known carcinogen. And I would also want to measure the particulate size that the dust happens to be of from this area. A lot of you might know that a micron is pretty small. It's like a millionth of a meter. That's pretty small. And if you get less than 100 microns, you're getting into an area where particulates may not settle out. They may be carried by the winds. They may be carried by who knows what. And they travel. And some of these particulates can get down as low as if they get below 10 microns, they can cause COPD type diseases. I personally have asthma. I'm worried about this. And it can affect people with emphysema. It can people with heart problems, like my neighbor across the road. It can affect mainly from the studies that I've read, mostly older people, those that already have some kind of condition, or very young children. And we do have a lot of young children in our area. Another concern I have is the blasting. The blasting is something that it creates sound waves going across the top of the ground, and these things can cause very, very loud noises. And I know from personal experience that this is true. And I also worry about lots of neighbors that may have breathing problems, as well as me. I also worry about our land values. I read about 3 different studies that were done back east, but it should be the same here. And they estimate land values depreciate upwards of 25% if you're close to the quarry.
If you can wrap up your comments, please. Thank you.
Okay, all right. I've got to cut out one of my important things. I would just like to say in conclusion that our quality of life, I feel, is in jeopardy if something like this were to go through. And I do worry about the safety and health of our kids and all the people that have made this a home. I've lived there 46 years. And in conclusion, why should our quality of life and investment in property be decimated by, other people that are expecting just to make a profit of this? So,
Thank you very
anyway.
much.
Thank you.
Thank you. I have Lindell Hagan.
Good evening. My name is Lindell Hagan. My address is 15418 North Little Spokane Drive, Spokane 99208. I'm speaking for Spokane Audubon Society. I presented information at the Planning Commission's meeting and dealt with issues as far as the vernal pools, the habitat that would be disturbed, the wildlife corridors that we depend on to get our wildlife around, the fact that habitat is disappearing at a rapid rate. I appreciate all the good questions that I heard being asked this evening. I think they deal with some vital issues. What concerns me is that it seems that someone who makes a profit off of changing designation is favored over people who are losing the value of their home and property. To say that this is not residential is, I think, a big stretch. People live there. They bought the property. Everybody bought that property knowing exactly what it was. It was large tract ag, it was rural traditional, and they moved there for a purpose, and to have one person disturb and undermine the things that these dozens of people have lived and invested in for years, I think you should consider very carefully. Regardless of what they say the goal of mining is at this time, once the designation is changed, anything can happen and they can apply for any possible use of that property. So I would consider it very carefully, and I oppose the change of designation from large tract ag to mining lands. Thank you.
Thank you very much. Next, I have Ron Calhoun.
My name is Ron Calhoun. I live at North 11225 North Brooks Road. And I really don't understand what all the hoopla-doo is all about here. I understand the blasting. This word blasting has been thrown every way but straight. And the only thing that's wrong with that, I'm not blasting. I never have any intentions of it. I'm not going to blast a thing. and Miss Higgins just stood up here and talked. Had she bothered to wait, I would have been more glad to take her and show her those aspen groves that she's so concerned about. She came in my driveway, got out, looked at the sign, took pictures of it, took 3 pictures of the aspen and left. Never called me, never talked to me again. And I've been out there since '94. You know how many of these neighbors have called me? None. Why? If they want to know what I'm doing, call me. I haven't kept it a secret. I'm not... My name ain't Castle. My name's not Rock Placing Company. My name's not Spokane Rock Products. It's Ron Calhoun. Call me and ask me. I have a well on my property too. It goes 80 feet. You think I want to run out of water? This is ludicrous. In my opinion, you're hunting for something that ain't there. They want to run their horses and their cattle all over the land and stomp it, smash down things, and destroy it. I want to move some rock. That's it. End of story.
Thank you. Next, we have Don Howell.
Good evening, Don Howell, 2820 South Pittsburgh, applicant, representing applicant. Three and 4. Will that scroll? Yeah. I'm going to deviate from prepared notes. Mr. Calhoun and myself, we've been in this process for well on to 3 years now, and it's been highly, highly scrutinized. When we started the process to position his property to where we could utilize a natural resource that's on the ground, and that means igneous basalt. It's a rock pile. This igneous basalt is an extrusion that is upward bound, and the whole intent of this process is to be able to go in with a dump truck and a track hoe, and you grapple it and you rip it out and you put it in a truck and you haul it away. So Mr. Calhoun's frustration that was so evident in his testimony is that we're nowhere intending to go to a pit environment such as the county owns within 5 miles of this product. Due west on Wood Road is Spokane County's facility. I don't know if there's a name or identifier for it, but I can understand people basically fearing that mining, you're going in, you're going to crushing gravel, dust, massive amounts of equipment because rock is heavy, but that's not the situation that we're dealing with here. From the very start, if you go back and look at the record, we have totally testified in the conditional use permit process that our objective is to simply harvest some rock. And that term harvesting has been poo-pooed, but we're not crushing on site, we're not fracturing on site. Our intent is to get boulders removed that will be another entrance to our Spokane International Airport. That's the kind of rock that we have. And right now, on an economic basis, I also share Mr. Calhoun's frustration to be chastised over the fact that he has a natural resource that he is criticized for wanting to utilize that and put rock into the community that's used for decorative landscaping, for people improving their homes visually to the standards that we hold as a society. So that's a big issue here. In the conditional use permit process, the project was thoroughly vetted as to access by the Spokane County Engineering Department. There were terms and conditions put on to that process. The conditional use permit was fundamentally denied because in that process, there is a requirement that you stay 1,000 feet away from your haul road from a residence. And we were able to get 800 feet and not reach the 1,000-foot dimension. So that was the critical issue about haul road. So I'll conclude my comments. Thank you.
Thank you very much. Next, we have John Kirsten.
Good evening. My name is John Kirsten. I live at 11416 North Wood Road, Reardon, Washington, 99029. Although my address is out of Reardon, I live in Spokane County. And the rock quarry that Don was speaking of is approximately 2 to 3/10 of a mile from my property. It is called Spokane County Rock Quarry, Wood Road Rock Quarry. That thing ran, Spokane County ran it. It ran 24/7 for probably 2-3 months straight. They did blast. I have a new well. It's 420 feet deep. Didn't affect it. None of my neighbors were affected by it. I shared a well with my other neighbor for a while before I had my new one put in. That was only 120 feet deep. Didn't affect it. The rock quarry you'll hear about on Wood Road, they did grind there. They blasted, they ground it. There's huge mounds of chip seal there, and that's what the county is using it for, is chip seal, and it didn't affect any of our, it didn't impact any of us. So I have walked that property. I've walked every single acre of Ron Calhoun's property. It's exactly what it is a rock. Every bit of it.
Great, thank you. Melissa Myers.
I also have other pictures.
So I was going to say those are directional. If you want to pull it down,
Down a little bit further. I don't want to break the thing.
directional. And if you'll start with your name and address for the
Okay.
record, please.
My name is Melissa Myers. I live at 10312 North Brooks Road, which, as you can see in this picture, it is the very first house on the corner of Brooks that goes off to the Mr. Calhoun's property. I purchased this property in September of 2015. When I had purchased this property, there was no notification saying anything about mining. I actually found out about it a week into my moving in. I had purchased my property as residential, with eventually, a couple chickens, ducks, geese, whatever, I personally did not spend that kind of money to have dump trucks literally driving straight through my front house. I mean, as you can see where the road is and where my house is on the corner and where my yard starts, there is no separation there. And if you know what basalt rock is, what kind of vehicles are going to be hauling those out are going to be over 2-ton big dump trucks running down a residential street, because everywhere down that road is nothing but houses. It is a dead end. When you go up that road, you're only going to houses. It should be really a private drive because there's no other reason to be up there other than either visiting your family or going home. As you can see, in the front part of my house is nothing but windows. That is a big concern for me when I think of small itty-bitty rocks falling out and either bouncing off, chipping my windows, which is going to cost me a fortune. That money that I don't have. And I just don't understand why someone should make a whole bunch of money and I should take the risk when I have no part of it, but I am taking the risk of not only polluting the water that runs through to my well, because it's an aquifer kind of thing, and also the dust, the chemicals, like I said, coming out from rocks, and rocks do give out chemicals. So anyways, I park my vehicles right, because it's a circular drive, I park my vehicles. My windshields is a concern. As you can see, that road is small and it is dirt and it should have, and I'm not sure what the weight limit is, but it's nowhere it can take part of big, heavy dump trucks. And when I mean dump trucks, I mean the kind that you find going up and down by Central Premix out in the valley. I did not spend all my money to live next to that. So I would think, you know, for being a residential area with agricultural, which means it could mean anything for agricultural, having horses, having chickens, not just necessarily growing hay or whatnot. And when you think of the road that they also have to go down to deliver that rock, there is the Spokane Family Farms. It's a GMO dairy. And when you think all that kind of dust and ash, what is that going to do to their crops that they grow out on Cooley Heights, which is essentially the only way. So thank you, thank you, thank you.
Thank you very much.
I don't want to shock your system, so just wait.
Roger, I cannot read your last name, I apologize.
My name's Roger Kepke. I live at 11119 North Brooks Road, just adjacent to the Calhoun property. The distance criteria, this is what I would have to live with if this project was to go forward. Between 750 and 800 feet is my front door. That rock pit on Wood Road, I can stand in my backyard and I can hear that, which is 3.5, 4 miles away. So let's shrink that down to 800 feet. That's me. That's the noise I'm going to hear at my house. The question I have is the proposed classification area of 40 acres or more, which Mr. Calhoun has 78, and meets the criteria listed under 14.616.410 of the code 14.616.410. And if I'm wrong, I apologize. This is all new to me. The portion shall not be reclassified from large tract agriculture zone to another designation. The rezone use land cannot conflict with existing agriculture uses. And that's what I have. I have about 86 acres of land that I raise horses on. I've been waiting quite a few years to establish a good breeding and training facility. But with this rock movement, hauling logs, you know, I'm kind of iffy about building good facilities and then nobody comes and uses it. So I'm kind of waiting to find out what the process is going to be. The main road, as Melissa was saying, is very narrow. I also, I forgot my chip to bring. But the road is so narrow that when I drive my truck down that road, and my neighbor has a little Volkswagen, we can go by each other slowly. You put an 18-wheeler on that road in a truck, it's not going to happen. You don't have enough room. The roads are extremely narrow. Hazards, we have children out there walking around, waiting at the bus stops. going to and from school. You have these trucks going by every day. I don't know what the kids are going to do, where they're going to go. To me, if I was a parent that had a child that was going to school, I would be very, very concerned about that. The other type of hazards, which was mentioned on the wells, and the commissioner brought it up, is if anything happens to a well, who's going to be liable? Oh, well, of course, they're going to turn to the homeowner and go, well, you know, that's your problem. You have to get an attorney and go through the legal process. Why? You know, we moved out there, we all knew it was agriculture. In my 85 acres, I have 12 acres in front that is Timothy grass. I grow it every year. I have about 11 acres in the back that's Timothy and mix. I grow that every year. Yes, there is rocks on my property. Yes, you can farm it. Yes, you can harvest grass. The condition of some of the land around there happens to be depleted because of the fact that they brought people in to haul logs, move rocks, and they destroyed the land. Now they're saying, oh, it's just rock land. Well, it wasn't that way in the first place. It was just like what I own. We had cattle out there before. Now that they destroyed it, they want everybody to think it's basalt land. And I don't really think it is. My time's up. Thanks, guys.
Thank you very much. Carol Marshall.
My name's Carol Marshall. My husband and I live at 10512 North Brooks Road.
Dead end piece. Brooks or Burnett and Brooks, they make a circle down here.
We don't get mail delivery on our road. We have to go out to the intersection of Brooks and Burnett. Paper doesn't deliver down there. School buses don't come down there. So there's a hub of activity that happens right where that last section of Brooks Road meets Burnett. There's also a hill that comes down. My concern is some of the big trucks that may be coming out that road, when they're loaded, they may take the longer, not so steep path going down Brooks out to Cooley Height. But if they're coming back empty, there's a good likelihood that they'll come down that steep hill, which then they have to cut the corner, turn the sharp corner to get back on the dead end piece. And Melissa's house is right on that corner. It's just a bad situation. I can see that happening rather than two big trucks passing on the other road. My concern is my well. I don't want something to happen to my well that I'm going to have to prove that somebody else did something to it. I don't know how I would prove that, but I know it's going to cost me a lot of money if I lose my well. I'm concerned about big trucks on that last piece of North Brooks Road. It's not built for big trucks. You can barely pass two vehicles now. Kids walking, people going out to get their mail, oftentimes they walk or they use a four-wheeler. So there's not just cars on that road, there's pedestrian, traffic. And the last thing I want to say is, we're going through this process to get this rezoned. If something happens, if it gets too expensive and Mr. Calhoun decides he's not going to go through with it, or the restrictions are too cumbersome, an out for him is he just sells his property. But the rezoning stays, and we all live with it. And it's likely that if it's rezoned to mining, whoever's going to buy that property is going to mine on it. So we're stuck with it, whether he does it or he sells out to somebody else. And that bothers me too. We're just screwed either way. Thank you.
Thank you. Will Schimmels?
Will Schimmels, 10902 North Brooks Road. Thank you for letting me speak today. We've been out on Brooks for about 8 years, and it's a quiet, dead-end road, and really enjoy raising our kids out there. We've owned the property for about 10. But I got a few points here I'd like to cover. The county treasurer's office reported that the applicant's property is currently tied up in federal bankruptcy. I was not able to determine, because I'm not an attorney, whether rezoning of the property that is tied up in bankruptcy is even allowed. In looking through the bankruptcy records on Schedule B, it states that any transaction involving debtor's real estate, which would be Ron Calhoun's real estate, must be authorized by court order. So I'm hoping that we're proceeding with caution here in terms of what the federal bankruptcy court has over this property. The applicant is several years in arrears for property taxes of which the county cannot collect due to the property being tied up in the bankruptcy. If this property was not held in bankruptcy, it would have gone to lien foreclosure by this point. We wouldn't probably be here tonight. The applicant began a illegal mining operation on the property approximately 9 years ago without any permits. The property owner of 11119, Roger Kepke, had to alert the county of the illegal mining operation at the applicant's property in order to get the operation shut down. From what is, I think it's important to look at the character of the applicant when considering this proposal. From what is listed above, it appears that the applicant does not play by the rules. There may be an exception or an expectation of generating tax revenues from this proposed zone change. It's my speculation that the county would not receive its due benefit based on who we're dealing with here. And to further that, I'd like to share with you what I received from David Jensen, which I believe is the code inspector for Spokane County. 2006, there was a complaint filed against Ron by Roger Kepke. And then in August 4th of that year, 2006, a notice of code complaint investigation. Go with me here, I'm just kind of running through this. August 7th, another notice of complaint investigation filed by the county. August 14th, a stop work order was filed by the county to shut Ron's mining. It says here, mining in a zone which mining is not permitted. Let's see here. August 28th of 2006, another stop work order. This one says that this matter will be forwarded to the Spokane County Prosecuting Attorney's Office without further notice from the office for the appropriate legal action. What I'm getting at here, my time's up, you can see there's a history. I'll jump to 2007, where Roger Kepke is emailing the county saying that, let me see here, as of 3 p.m. Saturday, April 20, 2007, large excavators are in place with trucks moving rocks from Calhoun property. Another email on Sunday morning, April 29th, 7 a.m., the digging has already started. I'm really thinking this person is well above any type of laws or rules that apply to proper mining or, let's say, land clearing. And then Roger says, I sure hope we can put a stop to this once and for all. It's a history of non-compliance, and I hope that you guys will do the right thing and deny this process. Thank you.
Thank you. Julie Schimmels?
Hi. Good evening. My name's Julie Schimmels. I live at 10902 North Brooks Road. And if I have 3 minutes, what I think I would best spend my time doing is introducing you to where we live. If I promise to speak up, can I? From here to here, approximately a half a mile. Drive is narrow. Our land right here, I could take a picture
our land, and I could come up, especially if I do it in the middle of winter. All the leaves have fallen off our deciduous trees. But our land is forestry. So to paint the whole area as a wasteland of scrub grass is not fair. I can tell you that half a mile down here at this famous corner that we've all been talking about, that's the bus stop. So the bus drops off the kids here, and they have to share this road with hauling trucks home every day. To me, that's residential. Our kids ride their bicycles, and my kids cross this road to go play with their friends. Our land has turkeys, coyotes, moose, deer, you name it. We haven't seen a bear. We have evidence of big cat on our property. And to bring this type of operation into that, I mean, it sounds dramatic, but it's a lazy little valley. Nothing's up there except for people who live up there. And this is a huge disturbance to bring trucks in and out. I just wanted to give you, if I may, permission to not change to mining or to mineral lands. Spokane County Zoning Code 14-620, or sorry, .620.100, at the conclusion it says, the mineral land zone is intended to ensure continued development of natural resources. I'll let you read the middle section there, but at the end it says, and to assure that mining activities do not detrimentally impact the environment or surrounding land uses. Instead, all the other neighbors around who have found that maybe their land doesn't fit the ag soil types, they've gone to rural traditional on this map. And rural traditional, Spokane County Zoning Code 14.618.100, the rural traditional zone includes large lot residential uses, ... and it says, industrial uses will be limited to industries directly related to and dependent on natural resources, which is exactly the term that Mr. Howell used to describe, is they want access to their natural resources. So to take the leap from agriculture all the way to mining or mineral lands, and Mrs. Marshall pointed out, once that's done, it's done. So there is not just a plan A and a plan B, but there are many other options. Thank you for considering them.
Thank you very much. I have no other yellow slips tonight. Is there anyone else who wishes to testify? Second call. Is there anyone else wishing to testify tonight on hearing item number 6? Third and final call. Anyone wishing to testify tonight on hearing item number 6? Seeing no one move forward, I'm going to go ahead and close the public hearing and actually look for a little bit of direction from John, because I believe this is part of a bigger package. So can you walk us through next steps?
Thank you, Commissioners. It is. This is part of the annual amendment cycle, and as a result, you've already received the Planning Commission recommendations, and so you do have another matter which is scheduled for a public hearing in May, and so you could take this matter under advisement and set a date for a decision only. And I think that, Madam Clerk, we know that we have a date in mind. If you want to do that, then you would make a decision on all the 2015 annual amendments at one time. That way give you time to consider this, or if you want to take some other action, set a date for deliberations or a workshop, you could do that as well in that interim period. But I think we're looking at May 24th as a potential date for decision, and that would be give us a chance to have our hearing on the other matter, and then you consider these all at one fell swoop.
Okay. Commissioner French.
Mr. Peterson, I'm asking you to refresh my memory. On Tuesday, May 24th, we have that evening set for considering 15 CPA-03. And so, and this one is -01. Do we have any other hearing items that we're going to be considering between now and May 24th? So go ahead and answer that one. And then
No, nothing that relates to these kind of topics or for the annual amendment cycle.
So we could conceivably set May 24th as the night to render a decision on both 03 and 01.
Right.
Actually, and
Okay.
all of them.
Actually, all of the one you,
There's-
The others that we did not choose to have a hearing on,
Correct.
but that were recommended by the Planning Commission for adoption.
So that's actually,
So-
I think, the recommendation is that on the 24th, we would take action on all of them after having the second hearing.
So, Madam Chair, I'd like to make a motion that we keep the record closed on 15 CPA-01, and that we continue this item to the 5:30 PM meeting for May 24th, 2016 for final consideration as part of the package, with the other items being considered as part of the annual comprehensive land use plan amendment process for 2015.
Second.
I have a motion and a second to continue this item for decision on May 24th, 2016 as part of our decision regarding the entire, all of the comprehensive plan amendments that we will be reviewing. So any further discussion on this item? Yes, sir.
I would just like to say thank you to all of the folks in the audience that came down to share your observations, your testimony, your history. You know more about this property than we do, and I appreciate the fact that you've taken time out of your evenings to come down and share your stories, your observations, your history with us, so that it helps us make hopefully a better decision as we move forward in considering whether to approve this action or not. So thank you very much for taking time out of your nights to join us.
And I do need to state that we are continuing this for decision only, just for clarification, in case I did not repeat that. But it's just to allow, for those of you in the audience, we have other comprehensive plan amendments that have been put forward, two of them which we are doing a public hearing on, but we'll take all of them together as a decision on the 24th. So that's the reason for not making the decision tonight, is they'll be taken as a package. And thank you for coming down and sharing with us your community and your thoughts around this issue. It takes time out of your busy schedules, and we do appreciate it. Any other final comments? Yes, sir.
I might just clarify, the reason why we're doing it all on the same night is that state law requires that we consider all the amendments as a group. So we're not doing it just for our own convenience. That's the way the law mandates that we take actions on these annual amendment processes. So just wanted to provide that clarity for you.
Any further comments? Okay, seeing none, all in favor of the motion say aye.
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 Passes 3-0. Okay, so that takes us to item number 7 on our agenda tonight, which is open public forum. Is there anyone who wishes to speak tonight on any item that is not on our agenda? This is your opportunity to do so. I don't have anyone signed up, so second call for anyone wishing to speak at our open public forum. Third and final call. Okay, seeing no one moving forward, that completes our formal agenda for the night, and we wish you all safe travels home and have a great evening. Thank you.